Okay, I guess it's time we start this webinar. First of all, let me welcome all of the participants with a special appreciation to some judges who are also attending this webinar. Let me first introduce myself to all of you. My name is Vaughn K.S. Chen, a practicing barrister arbitrator at Ronnie Wong's Senior Counsel's Chambers in Hong Kong. Also a council member of Hong Kong Institute of Arbitrators. Let me take this chance to introduce our speaker today, Professor Dr. Colin Ong, Senior QC, Queen's Counsel. Colin is Queen's Counsel at 36 Stone in London, Chartered Arbitrator and Counsel at Eldon Law LLP in Singapore. Also a senior partner at Dr. Colin Ong Legal Services in Berlin. You may not know he is the first English still appointed to the International Commercial Expert Committee of China's Supreme Court. Very recently, the Legal 500 London Bar 2021 commends him as on top of material and the law, and experience in both common and civil law. Also very recently, Who's Who legal arbitration thought leaders in 2021 commends him as a talent strategist who is able to think very quickly on his feet. His mastery of civil law gives him an immeasurable strategic advantage. His scope of experience in arbitration is truly impressive. Well, thank you so much, Colin, coming to this webinar. Without further ado, let me remind all of the participants here. First of all, these webinars will be recorded, and your video function has been disabled. And if you have any questions, please type the questions in the Q&A box. And also, please, at the end, submit an evaluation form. I will pass the floor to Colin, and we will leave the last about 10-15 minutes for Q&A session. Thank you so much, Colin.
Thank you very much for the introduction, Vod. Good morning, good afternoon, and good evening to all of you, wherever you may be. First of all, I'm grateful to the Hong Kong Institute of Arbitrators for inviting me to present the seminar. I also thank all of you for taking time out to join us today. And I've been told that we've got participants from 44 countries with us here today, and the great majority of you come from civil law jurisdictions. The doctrine of res judicata is one that sometimes ignites heated exchanges between counsel and between tribunal members. There's often a clash of civilizations and ideology. And this is due to international arbitration sees the two worlds, civil law and common law, meeting quite often, and lawyers from the two different worlds have very different ideas as to certain legal concepts, and res judicata is no exception. So the clash of ideology and civilizations between the two worlds focus mainly on the meaning, the nature, and the scope of res judicata. The terminology for the different subspecies of res judicata also differs from jurisdiction to jurisdiction within both civil law and common law jurisdictions. At the heart of the res judicata doctrine is the concept of preclusion. The preclusive effects of previously rendered judgments upon subsequent proceedings is very narrow in civil law systems when compared against the more extensive variations and approaches that characterize the common law tradition. The common law world has a larger variety and scope of res judicata doctrine due to the fact that judge-made law differs from country to country and different traditions. Even the English law common law is different to the US law common law. There are differences. This also applies around the Commonwealth jurisdictions. But litigation and arbitration counsel often reach out for doctrines such as res judicata or issue estoppel to narrow the scope of a case, as well as to apply pressure as part of overall case strategy. I shall spend the first half of my talk setting out the concepts of res judicata, which are applicable in both litigation and arbitration, in civil law and common law. Whilst I usually tend not to use slides, as a majority of our participants here today are from civil law jurisdictions, I thought it would be more helpful to show extracts of case judgments that form part of most common law jurisdictions. And I shall further summarize these slides to make it more digestible. So we go straight into the slides now. So res judicata or res judicata is the Latin term for a matter decided. So as explained earlier, it's a doctrine that precludes re-litigation of the same claim that was highlighted, that was litigated between the same parties in a prior case involving the same facts and case and decided in a final and conclusive decision. At its core, res judicata is meant to assist in providing legal certainty for the arbitration and litigation processes. If used correctly, res judicata assists in preventing unnecessary waste of time and costs to parties as well as judiciaries. Res judicata seeks to prevent future decisions from contradicting earlier ones, and also can assist litigants in not having to deal with multiple and conflicting decisions from different courts or tribunals. The res judicata system has been around for a long time. It's inherent in all judicial systems in some form or other, and it's existed since the times of the ancient Greeks, the ancient Hindus, and the Roman legal systems. And res judicata has sometimes been said to have both positive and negative effects. So the positive effects of res judicata can be seen in the enforceability of a judgment or arbitral award, which becomes final and binding on the parties. And the positive effect of res judicata is often explicitly set out in legislation of states, international conventions, the UNCITRAL model arbitration law. So we have all used this, even if we don't think about res judicata in its negative form. So Article 3 of the New York Convention requires signatories to recognize arbitral awards as binding, that is res judicata. Similarly, Article 35(1) of the UNCITRAL model law, which applies in many countries now, one third of the world, it states also that arbitral awards are binding. And we also see these crop up in negative forms, which I'll go into. But basically, when one talks about the negative effect of res judicata, it means that once the subject matter of a dispute has already been decided in a final judgment or award, one cannot bring these up again in a subsequent suit in a different country or a different seat of arbitration. This is where there's a wide area of divide in the scope of the res judicata doctrine, and different legal systems take different approaches. They have divergent views as to what parties assert is res judicata, and there are divergent views as to when the court judgment or award acquires the effect of res judicata. It's a comparatively much more straightforward process to sum up civil law concepts of res judicata. Whilst there are divergent views within civil law jurisdictions on the treatment of res judicata, there are a few key principles of res judicata that are applied throughout civil law jurisdictions. The dispositive of a judgment or award, so this is the final part, and the court finds and the tribunal finds. So the dispositive part are what constitutes res judicata in civil law jurisdictions. And the ultimate decision then becomes res judicata with respect to issues which have been explicitly raised and decided in contentious proceedings. There will be no res judicata effect to matters which were not specifically raised during the hearing, even if the court or arbitral tribunal rendered a decision on such matters. There is also no res judicata effect given to issues which were raised during the proceedings, but were not decided upon by the court in the dispositive part of the judgment. And there is an important general principle in most civil law countries in relation to res judicata, and this is reasons underpinning the judgment itself do not have res judicata effect. Now, while the reasons given by a court may be relied upon to interpret the dispositive of the judgment, or to discern the interpretation and the breadth of the court's judgment, these reasons do not in themselves have any res judicata effect. But civil law judgments have res judicata, which have res judicata effects, will have preclusive effects. This means that either party would be precluded from relitigating a claim that has been decided in the previous judgment's dispositive. So the civil law doctrine gives rise only to the direct petition of res judicata, and it does not encompass the wider common law petitions of issue estoppel, and there are no similar concepts to the common law concepts of abuse of process. So civil law is a bit more straightforward than the common law. And no res judicata effect attaches to any matters which were not raised during adversarial proceedings, and no res judicata effect attaches even if the original court or arbitral tribunal had rendered a definite conclusion on those issues. The test in civil law jurisdictions is often referred to as a triple identity test. And that means you look at three separate factors: the object, the grounds upon which the claim is based, and the parties. So the identity of the object means that the relief that has been sought in the subsequent court or subsequent arbitral tribunal would have to be the same. And the identity of the grounds means that the subsequent matter is also based on the same legal basis as in the previous case. Identity of parties is important. It precludes unrelated third parties from being bound by a prior judgment or award. I'll now quickly go through the common law concepts of res judicata. So in common law, res judicata is developed through case law. It's a judge-made. And as I said, it's a much wider concept for the common law jurisdictions and in the civil law jurisdictions. And most importantly, common law jurisdictions accord res judicata effect to the reasoning process of a judgment. So even if it did not make its way into judgment, if it's something that has been found by previous judge or tribunal, it would be res judicata. So, and for those who are interested in looking at how different civil and common law countries in Asia deal with res judicata, this subject matter is dealt with in a publication by the Asian Business Law Institute, and it's called the Asian Principles for the Recognition and Enforcement of Foreign Judgments. You can do a Google search for it. Right. Res judicata has been described by Lord Sumption as a portmanteau term, which is used to describe a number of different legal principles with different juridical origins. So the first principle is that once a cause of action has been dealt with, that ends the matter. That's cause of action estoppel, and a party cannot challenge the same cause of action in a subsequent proceeding. And the second principle is where the claimant in the first action does not challenge the outcome of the case, he may not bring a second action on the identical cause of action. So important case, Virgin Atlantic and Zodiac Seats. Under the common law, the concept of res judicata in essence covers the defenses of cause of action estoppel and issue estoppel. There is a third subspecies of res judicata known as abuse of court process, which is also sometimes referred to as the Henderson and Henderson doctrine, or the extended doctrine of res judicata in Singapore. Lord Gough in the Indian Grace referred to the could have and should have principle. This was first coined in Yat Tung Investment and Tao Heng Bank. And in essence, it would be an abuse of process to raise in another subsequent proceeding matters that have already been litigated in an earlier proceeding. So this Lord Gough was quoting from Lord Kilbrandon, who in turn referred to the original case of Henderson and Henderson in 1843. So there is a distinction where people tend to cluster action estoppel, cause of action estoppel, and issue estoppel on one hand, and the doctrine of merger of judgment on the other hand. And it is important because a judgment of a foreign court is also recognized as being able to give rise to an issue estoppel. So this was set out in both the House of Lords and Karl Zeiss Stiftung, and also in the Indian Grace. So the application of cause of action estoppel or issue estoppel will allow a party to defeat the defenses that are inconsistent with earlier judgments or which have been rejected in earlier proceedings. So another very important necessity in common law jurisdiction in order to count as res judicata, that judgment has to be final and conclusive on the merits in the country where the judgment is made. So once the judgment is made in that foreign country, it cannot be attacked for an error of fact or an error of law. And so long as the court that had pronounced the judgment cannot reverse or did not reverse that judgment, is res judicata. You cannot subject an earlier judgment to subsequent review or discharge it or modify it. So that's Karlsreich-Stiftung in House of Lords. And when faced with a challenge or assertion of res judicata, the second court or the second arbitration tribunal has to consider all the factors relating to the first foreign judgment or the first arbitral award concerning its enforceability. So the second court looks at its own laws, but also at what the foreign law says about the nature of the original judgment. And even though the judgment is under appeal, this does not mean that it's not a final decision. So perhaps one could say that the principles of estoppel cover both cause of action estoppel, which precludes a party from relitigating the existence of the same cause of action. And then you have issue estoppel, and this precludes a party from denying any matter of fact or law that had already been decided upon by the early judgment. So obviously a lot wider issue estoppel. Issues of fact will be dealt with. And in order to rely upon issue estoppel, a defendant in the common law court will need to show that the same set of facts has been dealt with as a cause of action in the earlier proceedings, and the final judgment had been provided. So, important case to note, Arnold and NatWest Bank. And this case is important not only under English law, but it's also taken root in many of the Commonwealth jurisdictions. So you cannot re-examine an issue unless there is new evidence that may change any particular substantial aspects of the case. But you cannot bring in new evidence if reasonable diligence could have been previously carried out. So if counsel in the previous case were negligent or failed to bring certain facts out, they would not be allowed to relitigate. And in essence, it is to save costs and time, because the common law jurisdiction is very clear that no man shall be allowed to litigate a second time when the issue has already been decided the first time round. Otherwise, there's no end to litigation or arbitration. So one can see the Arnold and NatWest Bank principles are adopted in Hong Kong, Novoseltsky. So the Court of Appeal referred to Arnold, and the test for common law, for estoppel is a fourfold one. So firstly, the judgment that's been relied upon in creating the estoppel, it must be from a court of a competent jurisdiction, it has to be a final and conclusive judgment, and it has to be on the merits, final and conclusive on the merits. And the parties have to be the same in both sets of proceedings, and the determination of the issue has to be very clearly set out in the judgment. And the issue, obviously, in the latter action would have to be the same as an earlier action in order to fall within the folds of the test for res judicata. The rule of cause of action estoppel dictates that once the court of competent jurisdiction decides a certain course of action, no subsequent matters, proceedings can be brought on the same action by the same parties or by their privies. So this is interesting because privity of interest is one exception to the general principle of the law of estoppel, because estoppel only binds parties to the previous litigation, because nobody has to be disturbed twice in the same cause. So this was summed up in the English Court of Appeal by Lord Justice Lloyd. But it's also important to note that sometimes the parties may not be identical, but they are bound nevertheless by way of issue estoppel, because issue estoppel also binds the privies of the party who are related in blood or title or interest. So for example, a set of beneficiaries who may be fighting trustees. So if one beneficiary has taken a certain action, it's been decided likewise, because they are all sharing the same interest. And the court, the second court or the second arbitration tribunal needs to carefully examine the extent to which the new party in the case before it had any interest in the subject matter in the old action, the first action, and the extent to which the new party is actually connected or is actually the party to the original proceedings, because of the closeness with the first party. And obviously whether it is just that the new party should be bound by the outcome of the previous litigation, because the new party was not the identical party in the case before. So the word just is an important one, because not only do we have the test in Arnold, but we have an exception to Arnold, the exception to issue estoppel, essentially the prevention of injustice exception. And so common law jurisdictions, they have discretion to remove injustices which may be caused by the strict application of issue estoppel. And the overriding philosophy is that issue estoppel is meant to support justice and not injustice. So Lord Keith has explained this, and he's also quoted in many different judgments, both within England and also outside. So let's look at some of the examples where Arnold, the exception to Arnold, has been applied. So one can see it's been applied in Long Phuc Hoa, again Secretary of Justice, and it's important that in order for estoppels to work justice between the parties, the courts have to recognize that in special circumstances, an inflexible application of this rule in Arnold will have the opposite effect. And we see this in Malaysia as well. In the case of Malaysian Court of Appeal decision of Abdul Rahman and DBKL, Justice Sri Ram referred to the exception in Arnold and why one should not apply it strictly in certain special circumstances. There is one court that bucks the trend. So Singapore has taken a different approach to the Arnold exception. The Singapore Court of Appeal in Royal Bank of Scotland and TT International held that the Arnold exception should be construed in a narrow manner in Singapore. And the main, in a nutshell, the Singapore Court of Appeal held that a wide formulation of the Arnold exception runs the real risk of encouraging disgruntled litigants to try their luck repeatedly. So this was set out by Chief Justice Menon in RBTS and TT International. And Singapore has also changed or reformulated its test for issue estoppel when it comes to dealing with foreign judgments. In the case of Merck, Sharp and Merck, the Singapore Court of Appeal dealt with this doctrine of issue estoppel in relation to a foreign judgment. And the dispute dealt with whether the appellant in the Merck Sharp case was bound by an earlier English court decision which had interpreted an agreement between the parties' predecessors setting up parameters over the use of the name Merck. And the Court of Appeal in Singapore set out a series of guidelines as to the test for issue estoppel. Firstly, so where there are multiple foreign judgments competing between the same parties, the first in time would be recognized for the purposes of creating an estoppel. So assuming there was a judgment from the UK and there's one from Hong Kong, if the one from Hong Kong was the first judgment, then the Hong Kong judgment would be the one that's recognized and not the UK one. And the next rule is that if there's an inconsistent judgment from Singapore, where there's a prior judgment or a subsequent judgment, you do not look at the foreign judgment. It should not be recognized or as a priority, because res judicata should be given effect. Local Singapore decisions should be given effect. And in order for a foreign judgment to be considered as issue estoppel, the actual decision on the specific issue of the subject matter of estoppel has to be final and conclusive. And lastly, issue estoppel does not apply to a foreign or local judgment on a pure question of law that does not directly affect the parties' rights or legal relationship. I now quickly deal with arbitral awards and res judicata effect. So as I had stated earlier, well, first of all, let me sum this up. In common law jurisdictions, you will not find any statutes that would explicitly state that an arbitral award has the effect of res judicata like a court judgment. But English law has long recognized that the doctrine of res judicata applies to arbitral awards, and case law developed almost 3 centuries ago to recognize this doctrine of res judicata being applicable to arbitral awards. Lord Diplock in Fidelitas Shipping made it clear that issue estoppel applies to arbitration as it does to litigation. And the Singapore Court of Appeal in BTN and BTP also made it clear in Singapore that the nature of a res judicata challenge is the same in both court proceedings as well as in arbitral proceedings. So because arbitration is a consensual process between parties, an award that has been disposed of that has disposed of a dispute between the parties will be enforceable under the New York Convention. And there is no appeal process from international arbitration, so therefore the award is final and binding. And as we said, Article 3 of the New York Convention requires signatory countries to give res judicata effect to foreign judgments. And the New York Convention makes it clear that an award on an arbitration agreement can be enforced if leave the court in the same manner as you would a judgment. So countries which have adopted the ancestral model law as part of their jurisdiction will all have similar laws, and it will make it very difficult to challenge an award at the seat of arbitration. and the grounds are exhaustive, and there are 7 grounds under Article 36 of the model law. In some countries, legislation has been amended, such as Singapore's International Arbitration Act, to add on breach of natural justice as an additional ground to challenge such an award. And it is unlikely that the tribunal's decision to ignore a res judicata defense can fall under a breach of natural justice. We've dealt with the model law. Most, if not all, institutional arbitrations have rules that provide binding effect to awards. It makes it very clear. And it's the same for ad hoc arbitrations, which are governed under the arbitral arbitration rules. Article 34(2) makes it clear that awards are made in writing are final and binding on the parties. Straightforward. We now get to a more interesting topic, and this comes up a lot, and it's usually part of case strategy. So the question that is often arises is res judicata a matter of jurisdiction or a matter of admissibility? So jurisdictional challenges hinge on whether parties had agreed to arbitration and to the jurisdiction of the tribunal. And when a party raises a res judicata challenge, that party is not challenging jurisdiction of a tribunal or even matters that are being sent to the tribunal. It is actually challenging and alleging that the claim or claims is defective in a certain manner, and a res judicata objection challenges and finds fault with the claim itself. It disputes that the claim should not be heard in any seat. And this is because tribunal decisions on jurisdiction may have res judicata effect, but tribunal decisions on admissibility do not. So this designation is quite important in arbitration litigation because it sets out the type of review that a court at the seat of the arbitration will have on the tribunal's decision. If the challenge on res judicata is classed as jurisdictional, then the courts at the seat will have the right to come in and have a right to finally review the award. But if the challenge is classed as one of admissibility, the courts at the seat will have no right to review the decision. So this is a pure strategic decision for counsel when they run the case as to how they wish to put the matter of res judicata. So these disputes often they often continue, and they're not easily solved. At the end of the day, again, it depends on the facts and it depends on the situation, and that would determine how counsel would decide to run his or her case. So I now move on and deal with this issue, which is a little bit more interesting and controversial. So the rule in Henderson and Henderson is a central rule in res judicata. It's a third subspecies, as earlier said, and it's a doctrine that prevents a party from raising claims or bringing up defenses that could have and should have been raised in the earlier proceedings, but were not. So similar Henderson rules have developed in other common law countries. In Hong Kong, you have it in Singapore. You have the Henderson rules. I call it the Henderson doctrinal rules. They all operate in a similar manner. Their aim is to prevent any abuse of court process from taking place, including disruption of the principle of finality. So Singapore has also adopted the doctrine, but it's changed it a little bit, it does refer to Henderson and Henderson, but essentially they work in the same way as Henderson and Henderson, and it applies to so extended doctrine of res judicata actually extends well beyond cause of action estoppel and issue estoppel. It extends to cases where a particular point should have been raised in the early proceedings, but it was not. So again, Royal Bank of Scotland and TT International. And another important Singapore judgment, the case of AKN and ALC. So the court may disallow a party to raise these points if they had not raised them earlier in the arbitration. So at the end of the day, this could have and should have doctrine has been cropping up a lot in international arbitration, and both counsel and some arbitrators actually invoke the extended doctrine of res judicata, and they invoke them on grounds of protection of the dispute resolution process. So obviously the question that we have asked is, do arbitral tribunals anywhere have similar powers in this aspect as the courts? So we see that the Court of Appeal in Singapore referred to the UK Supreme Court case of Virgin Atlantic and Zodiac Seats, and to Lord Sumption's dictum. And so Lord Sumption said that res judicata is a rule of substantive law, while abuse of process involves the exercise of the court's procedural powers. So essentially, the doctrine of extended doctrine of res judicata should be treated more as a procedural issue rather than a substantive law issue, because then this ties in with its other name, abuse of court process. The Order 92 Rule 4 of the Rules of Court under the Supreme Court of Judicature Act. So this is where we Singapore lawyers would go for if we need to invoke the court's inherent powers, because nothing else assists. You know, where there's nothing else left, one goes down this route. But Order 92 Rule 4 is actually makes it very clear, the wording of it. It says inherent powers of the court. And inherent powers of the court are very broad. The father of the English White Book, Sir Jack Jacob, he explained that inherent jurisdiction means the inherent powers of the court to act to protect its own processes. So this is a starting point that one looks at, and then one starts looking, and I'm using the Singapore example, but it can be any example, it can be Hong Kong or any other Commonwealth country. You look at where the powers came from. So the current powers for the Singapore courts to invoke this doctrine of extended doctrine of res judicata, they flow from Section 18 of the Supreme Court of Judicature Act. And this is a source of powers, the direct source of powers for the rules of court, including Order 92 Rule 4. And it is not tied to international arbitrations, because international arbitrations are governed solely under the Singapore International Arbitration Act. Justice Anselmo Reyes, in the case of BXX and BXT, held that it was inappropriate to rely on the power derived from a rule of court to extend time in a primary legislation. I would say that by analogy, it would also be inappropriate to use the rules of court to extend the court powers into the Singapore International Arbitration Act, because the primary legislation is of a higher level and the rules of court is subsidiary legislation. But this does not end the matter, because some counsel and some arbitrators have gone the other way, and they have asserted that they have inherent powers under the Singapore International Arbitration Act, which of course is primary legislation. And they say they have powers under this legislation, specifically under Section 12(5) of the Singapore International Arbitration Act, to award any remedy or relief that could have been ordered by the High Court if the dispute had been a subject of civil proceedings in the Singapore court. So counsel and arbitrators have often also tried to take this route to say that Section 12(5) gives tribunals the same powers as Singapore courts in relation to the extended doctrine of res judicata. However, if we look at the wording carefully, Section 12(5)(a) deals with remedies and relief. So remedies and relief deals with substantive law remedies. So substantive law remedies would actually be dealt with together with the merits of the dispute. So I would say that Section 12(5)(a) does not allow counsel or arbitrators to tap into the inherent procedural powers available both through the courts nor under Section 12(5) itself, because when one reads Section 12(5), one needs to read it together with Article 28 of the Arbitral Model Law. And it is essentially rules applicable to substance of dispute. That's substantive law, it's not procedural law. The investment treaty arbitration is not the focus of this talk, so I should keep my comments short. I have written a paper on it, and if you want to find it, just Google me, Lexology, res judicata, and you will find the subject on the internet. But for now, let me just illustrate some examples which show a certain lack of consistency in international treaty arbitration on this doctrine. So arbitrators in different cases, they seem to reach contradictory decisions on identical issues. These are the exit cases, because obviously it's very hard to find redacted versions of arbitral awards. The ICC has them and some other institutions have them, but they are few and far between when compared to exit. And exit is all around, so people can look at the different decisions available there. So in the decision of SGS and Philippines, the tribunal held that it did not fully agree with conclusions reached by an earlier tribunal, different tribunal, in SGS and Pakistan. But both tribunals had to deal with the same interpretation of the same language in the Swiss-Philippines bilateral investment treaty. At the end of the day, the court, the tribunal in SGS Philippines said that the tribunal should defer to the answers given by the earlier tribunal. Although Article 53(1) of the Exit Convention only provides that awards rendered under this article, this Exit Convention, are binding on the parties. So this means they are res judicata in as far as the parties are concerned, but one still needs to look carefully at the background. And the tribunal in SGS and Philippines concluded that it is actually up to each tribunal to exercise its own competence to decide the applicable law and to look at each different bilateral investment treaty. An interesting decision was made in by the tribunal in Helnan versus Egypt, where an earlier Cairo award was deemed res judicata within Egypt. But the tribunal said that national courts and arbitral tribunals do not have the same authority because they're not performing the same duties in the same legal order, and therefore their jurisdiction does not have the same scope. The Helnan tribunal adopted the dissenting opinion in Fraport and Philippines, where the dissenting opinion said that the ICSID tribunal is not bound by the decision of the Philippine court, not even the Supreme Court, but it must be premised on Philippine law itself. So again, Article 53 of the ICSID Convention, it provides that only awards rendered under this convention are binding on the parties. But the SGS and Philippine Tribunal emphasize clearly that different tribunals constituted under the ICSID system should generally try to act consistently with each other, but it's up to them to look at the applicable law and which would by definition be different for each BIT and for each respondent state. So in other words, try to be consistent, but really in practice may not happen and quite often doesn't happen. One could conclude that decisions of arbitral tribunals over interpretation of law cannot bind a subsequent tribunal because arbitral tribunals are not superior courts. And one can even draw an analogy to Article 59 of the Statute of the International Court of Justice, where the Article 59 said that the doctrine of res judicata only applies to the parties and only in respect of the particular case that had been decided between them. So with that, I now come and look at what are the conclusions. So the conclusions are common law tests for res judicata, they are converging, but there are still differences between the different countries. So one can see different countries, Malaysia, Hong Kong, they were following the English exception to Arnold, but Singapore has chosen not to do so. But there are convergence because they all do follow Arnold. They do look at Henderson and Henderson. So there are instances of convergence taking place. But differences still continue to arise within civil law jurisdictions, which rely on statute law, and there are continued differences between the civil law world and the common law world in relation to the treatment of res judicata. We can also conclude that as more interaction continues between lawyers from different systems of laws, the understanding of the differences will continue to improve because one does not have to agree with another system, but it's important to understand how the other system operates. And so I would say that a greater use of res judicata in a proper context will help to control guerrilla tactics, which are and continue to be on the rise in international arbitration. And misunderstandings continue with subsets of res judicata, but the extended doctrine of res judicata in arbitration remains controversial. So with that, ladies and gentlemen, I think I have just finished in time, and I shall deal with questions now. Thank you.
Thank you so much, Colin, for such an informative and insightful presentation. I trust the audience would share the same will as I have now. Well, I trust all of you can understand that Vegas rules are still in place. That means no audience should call what the speaker has presented. Well, being a moderator here, in principle, I trust I may have the priority to ask question first. Of course, subject to Colin. What do you think?
Please, yeah, go ahead.
Okay. Well, Colin, very good presentation indeed. May I ask you, as a very experienced leading counsel in many high-stakes international arbitrations, would you tend to present the Judicata doctrine as a matter of jurisdiction or a matter of admissibility strategies in your game plan in relation to international arbitration?
Right. So my approach as lead counsel would be highly dependent on the factual situation at hand. So if I was acting for the respondent and had a tough case on the facts, and the earlier decision was against my client, then I would be more likely to try to mount the attack on res judicata as a matter of jurisdiction. Because then any decision on jurisdiction will need to be reviewed by the courts of the seat of the arbitration. So even if one does not succeed before the courts at the seat of the arbitration, there is another potential second bite of the cherry at the courts of the place of enforcement. But obviously, if I had a strong case, and wanted to rely on the earlier decision, it would be strategically better to mount the res judicata attack as a matter of admissibility, because you don't want to take the risk of having a new second round of arbitration.
Thank you so much, Colin. I can see there are quite a few questions in the Q&A box. Colin, have you had a chance to take a look, or you like to pick some questions that you like to answer first, or you like me to choose some? There are quite a few indeed.
Let me deal with, do you foresee the possibility of convergence taking place in Asian jurisdictions, civil and common law jurisdictions, and how to deal with principles of res judicata, by Steve Ngo. Yes, I think I had mentioned it earlier. There is convergence taking place, not just in Asian jurisdictions, but across the world. But it would be interesting to look at the publication that I'd mentioned, the Asian Principles for Recognition and Enforcement of Foreign Judgments. Let me try to find it. Yeah, Asian Principles for Recognition and Enforcement of Foreign Judgments, published in 2020 by the Asian Business Law Institute. It was put together by leading experts from each of the major civil and common law countries on various strands relating to enforcement of foreign judgments, and including res judicata. So I was fortunate to be one of the members in this interesting work. This publication was also cited by the Singapore Court of Appeal this year in Merck, Sharp and Merck. Right?
Yes.
Another interesting question. Do you think that the Arnold exception to res judicata will eventually be adopted by many countries, especially in non-common law countries? Well, this is an interesting question. The main principle emanating from Arnold and NatWest Bank is itself one based on issue estoppel. But this is a subspecies of res judicata which comes in only for common law jurisdictions. So because civil law jurisdictions would not have the common law concept of estoppel in the first place, there would be no need for an exception, the Arnold exception. So I would say there would be no opportunity for a civil law jurisdiction to consider the Arnold exception, because they would not consider Arnold in the first place. I see an interesting question. Is it harder to bring a res judicata defense in common law countries?
Yes, I also have this question in mind. Colin, please. Yeah, I think that would be a good question for, I guess, an advocate in intellectual arbitrations.
Okay, this is a very tricky question. Is it harder to bring a res judicata defense in common law countries or civil law countries? I think at the outset, I shall qualify my answer, and I shall say that it all depends on facts, and it depends on the law of the seat where the second arbitral tribunal is located. And it also depends on what type of res judicata subspecies one wants to deploy. Because civil law jurisdictions do not have the wider common law concepts of issue estoppel or abuse of process. So I think it's very hard to do a direct comparison, except for one subspecies. You can compare the direct petition of res judicata between civil law and common law, because both types, both worlds have the same. Comparing between the two, it is probably harder to succeed in the plea of res judicata under civil law, because under civil law, one needs to go through the triple identity test, where the object, the grounds, and the parties must be the same. And you can only look at the dispositive part of the judgment. Only the dispositive part of the judgment will be recognized. So quite often, I think common law counsel prefer to resort to issue estoppel, because the res judicata doctrine then applies to the reasoning process in the previous judgment. So it's comparatively easier to establish res judicata in the common law jurisdiction because you can look at the reasoning process. However, I would end by again qualifying my answer to say that it all depends on the facts and depends on the law of the seat where the arbitral tribunal is located.
Yes, indeed. I guess it's difficult to compare apple with an orange, right? In that sense, yes. Well, Colin, may I ask you another question from my perspective? Well, in your presentation, remember you had mentioned that an issue estoppel binds not only the parties to the earlier decision, but also their pivots. If they are not related by blood or are not part of the same network of companies, how would you, as an arbitrator, decide whether a party is a pivot to the party in a previous litigation or arbitration?
So I think well, it's a very good question. there's no clear-cut answer, but I would say that if a person has skin in the game, he would be considered to be a privy. I think, and looking at it, Lord Justice Floyd phrased it much more elegantly in the Resolution Chemicals case, because he held that a person will be treated as privy if he had a concrete, I believe he used the words concrete interest in the outcome. So that's a much more elegant way of phrasing it. So I would just say that if the person, he has something to gain, skin in the game, he would be considered a privy. So that would be a general rule of thumb, but there's no clear-cut answer.
Thank you, Colin. Well, of course, I have some other questions to ask you. If you like to let me ask you, or if you wish to take a look at other questions in the Q&A box.
There's quite a lot of questions.
Yes, indeed. Indeed. I trust the audience is very interested in this topic and would like to gain more insights from you.
I understand that the video will be made available to the parties. I think some of the questions are more on arbitration rather than res judicata. Most of the questions, I'm looking at it, they tend to all ask different questions of non-res judicata questions.
But lots of comments to please to comment your very insightful presentations.
Thank you.
Such messages in the Q&A box. So you have any particular questions that you may wish to share with the audience? Otherwise, I will fire you another question, if I may.
Go ahead.
Okay,
Go ahead.
well, as I said, this is the privilege of being a moderator here. Okay, I have another one. I'm just wondering, could one use the extended doctrine of res judicata to try to persuade a subsequent tribunal to not hear a claim or even a defense on the grounds that it could or should have been brought up previously in an earlier arbitration proceedings?
Well, obviously, the could have and should have extended doctrine of res judicata is now getting much more popular. You see this, it's quite rife in arbitrations in all over the place. I myself had 3 last year and 1 now. But I think first of all, there are no, it depends on which platform, whether it's a civil law or common law platform we're looking at. There are no statutes in common law platforms to say that an arbitral tribunal has the effect of res judicata like a court judgment. But obviously, case law dictates that it should. But it is unlikely that one would find this answer in any statute, because the extended doctrine of res judicata or abuse of process doctrine is a common law judge-made creature, and as such, we won't be able to find that in any common law common law statutes, and obviously it will not exist in a civil law side. So I think it's interesting. It would be important to then look at the lex arbitrae or the arbitration statute at the seat of the second court. And if we took the Singapore example, I would say that it's exceedingly challenging to try to submit that a tribunal has inherent powers of the Singapore courts, because obviously court judges have the powers because of the Supreme Court of Judicata Act and Order 92/4, the rules of court. But arbitrators just cannot tap into these statutes. So there is nothing at all in the Singapore International Arbitration Act that accords them with such equivalent powers. So I would say follow through the same thought process wherever you are in a different country. First of all, look to say where's the source of powers coming from. Where's the Himalayas in this, and where does the water start flowing down from? And if it goes down a certain path, and that certain path is only accessible by court judges, that ends the situation. Having said that, it comes up quite a lot, and I think skillful counsel may be able to persuade certain tribunals, certain arbitrators, that one should use this to protect the dispute settlement process. So I would say that this issue, this debate is not going to go away. And if you look through articles, you find learned articles around by learned silks and learned professors who say that, yeah, you can do that. You can borrow such powers. But I think these are all aspirational, but I cannot see how you make it happen by pointing out to a clear path in any statute. I'm sorry that the answer is a bit long.
No, not at all. I trust all of the audience would enjoy hearing your insights. Well, I can see the time. We still have 3 minutes to go. Well, may I know if you wish to share with us your final word on this presentation? Because I trust the audience would like to know, other than the law, in relation to arbitrators, for example, as a presiding arbitrator or party appointed arbitrator, would there be any dynamics by reason of different interpretations of res judicata? I just say sharing, perhaps there may not have been any conflicts in a tribunal, but just say, as an arbitrator, I like to know how other arbitral tribunals they may deal with, they may embrace such a situation.
So it's a very good question, because it's very real. So I have been in tribunals where you're sitting with very eminent people, people who are ranked top 10 in the world, and everyone has their own different views, and everyone starts exchanging very interesting write-ups on this issue. So I think it's not just a civil law common law mismatch or civil law common law difference, because I have seen in certain situations, even people within two civil law jurisdictions, they have very different ideals. Someone from Switzerland has got a very different idea from maybe someone from Germany, even though they speak the same language, they're both civil law, but the way they approach the subject matter is quite different. And even within common law jurisdictions, the approach is very different. And I think res judicata will continue to be one of the very important tools in the arsenal of a litigator or arbitration counsel, precisely because it's able to generate so much interesting debate and thought process, and you know, it can even buy time. So one can look at it like an interim measure type application. So it is very important. But we deal with this all the time, and usually people tell me, oh, I know nothing about res judicata. I said, that's not true. I said, you deal with res judicata all the time. I said, arbitration counsel. And they said, how come? So I said, well, what does Article 3 of the New York Convention say? You know, what does Article 35 of the model law say? You know, those are res judicata. It's binding an award. So I think it's a very interesting subject because we live with it and we all use it. But sometimes, unless someone you know, brings up the mirror and say, look, have a look at this. You've been doing this all the time. Now, just look at the negative aspects, because so what I've mentioned are the positive aspects of res judicata, but people tend not to deal with the negative aspects. And I think it's very important because if the tribunal does not understand this and cannot get a grip on such issues, you might have a runaway arbitration where the case starts dragging on and doesn't really help anyone.
Thank you so much, Colin. I can see the time now is all gone. I guess time flies while we were enjoying your presentation. Thank you so much again, Dr. Ong, QC, on behalf of Hong Kong Institute of Arbitrators to have given us a very informative, very insightful presentation. Well, of course, I'd like to use this airtime to do some advertisement as well, because we will have our next webinar on 23rd of November. So please come and sign up. Thank you so much again for all of the audience. Thank you so much again for Colin, for your very insightful sharing. Thank you so much. Thank you.
Thank you very much.
Thank you.
Thank you very much,
Thank you.
Bob. Thank you very much.
Thank you.
And thank you for all participants today for taking your valuable time to come here. Thank you.